Bootcamp presentation is being recorded. It is titled, What is a Security? Overview of Securities Laws for the General Practitioner. We will stop the recording after the PowerPoint presentation concludes and take attendees off mute so that we are able to enter into a discussion or address any client-sensitive questions. Our presenter today is Ryan Stoker out of our Baltimore office. Before we begin the presentation, I'll turn it over to David Can for a brief introduction. Dave?
Thank you. Ryan Stoker has been an associate with Whiteford, Taylor & Preston since 2013. So he's a veteran of our firm, and it's been my pleasure to work with him on many occasions, see him grow into a strong and effective counselor and advocate for our clients, including several that he's originated, and also to become a husband, dog owner, and father along the way. Prior to becoming an attorney, Ryan earned his CPA license and worked in an accounting role with several local companies, including publicly traded Medifast, Inc. Since becoming an attorney, Ryan has maintained his CPA license and has represented our clients on tax, business structuring, and general transactional matters of various types. But his major area of focus is securities law compliance in the context of private transactions, specifically representing issuers or investors in the private placement of sales of debt and equity securities. Ryan also advises companies on equity-based compensation plans, including the use of restricted equity, options, appreciation rights, and phantom equity. And some of his representative private placement deals include the sale of LLC interests of over $4 million on behalf of an issuer in the hospitality sector, sale of Series Seed preferred stock aggregating over $5 million on behalf of an issuer in the cybersecurity space, sale of limited partnership interests on behalf of private equity issuers, the purchase of Series A preferred stock by an investor who is the lead investor for a financing round, and purchase of convertible debt by a fund investor with a focus on providing initial financing to startup companies in technology and engineering. In this presentation, Ryan will describe what a security is and why a general practitioner should care about whether or not a transaction constitutes the sale or purchase of a security. I'm sure he'll also provide some context for the transactions that I described. Without further delay, I turn this over to Ryan Stoker.
Thanks, David, for that introduction. As David mentioned, I practice in the private placement of securities, whether debt or equity. And with that comes some regulatory compliance issues that I will discuss at a very high level today. The title is an overview of securities laws for the general practitioner. So not going to get too in the weeds here, but understand that, certainly myself and others at our firm have capabilities that go beyond some of this overview into more nuanced areas of the law. And, as David mentioned, some of the context of my transactions, I also practice in mergers and acquisitions, and there are a lot of interesting overlays between, issuing securities and M&A deals, particularly in this modern day world where there's a lot of rollover equity deals where, a seller is either taking a security as part of purchase price or a buyer is issuing a security as part of purchase price. So that kind of entangles securities law compliance there as well. So without, further ado, I'd like to kind of start the presentation with the kind of typical, disclaimer of, this is serious stuff, right? I mean, we're talking about a regulatory framework at both federal and state levels. And there's never a one-size-fits-all approach to securities law compliance. It's always heavily dependent on the facts and circumstances of each transaction. And, a lot of clients, particularly our startup clients, come to us with, hey, what's the big deal? Why do I have to go through all of these hoops and hurdles? And, I typically give them 3 responses of why you should care about securities law compliance. One is, you've got, the obvious enforcement actions that a federal or state agency can take against you. And that can include administrative or civil penalties. It could even, in some circumstances, result in criminal liability, depending on how egregious the non-compliance or infraction might be. The second response as to why you should care. Private actions, your investors can seek, recourse against you, outside of any agency enforcement. And kind of the risk there is, at the outset, they can have a rescission right, meaning, give me my money back. They can also collect, additional damages or other penalties related to those actions. The third and probably most practical reason why you should care about this stuff, it impacts future deal making. I can't tell you how many times we have had a client that has engaged in capital raising in the past where they've taken outside money from a third party, and there's a lack of compliance in that transaction. So, a year or two later, when they want to do another round of financing and they get, a law firm like ours involved, we look at it and say, well, gee whiz, it looks like you may have run afoul of securities regulations in this prior transaction. And, that is one, a disclosure that you would have to make to prospective investors in this future financing. It could prevent you from relying on certain safe harbor and compliance measures that I'll get into later. So it might jeopardize future activity of your client if in the past they had violated some of these laws. So that's the disclaimer. That's why we should care about this. And that's one of the reasons why I'm doing this presentation today. So just to take a step back of the framework of securities law, understanding the objective is important. When you're taking in money from third parties, those third parties are relying on the company, in most cases, the company that's selling the stock or making a promise to pay back a debt. They're relying on information about the company and how the company's doing. And related to that is the fact that these securities, whether it's equity or debt, there's not necessarily an inherent value to those securities. It's not like currency. The value only comes by virtue of the operations of the business. What kind of revenue is the business generating? What kind of earning power is there? Without that, the security is basically a piece of paper. So, in recognition of that, federal and state law tries to get that information into the hands of the investors, depending on who the investors are and what the transaction looks like. Our focus in terms of the framework will really be on the Securities Act of 1933, and that mainly relates to what I'll call the primary market or the primary issuance of securities. Is, we're not necessarily going to focus today on, I'm already an owner of stock and I want to sell it to some, other person, whether through an exchange or a private sale. What our focus on today is, we've got a business client that wants to sell its stock or other security to an outside investor, or we represent that investor that wants to put money into the company directly. And that's what the 33 Act, or what I call the Act in this presentation, is focusing on. And that's primarily the type of client that we represent here at Whiteford. So with those objectives in mind, we first got to answer the question of, what is a security? And it's a laundry list of things that constitute a security. And I've kind of given the excerpt here from the Act. I'm not going to read it in full, but the usual suspects: note, stock, bond, debenture, and a host of other things. The states largely follow the same definition. So whether you're dealing with a federal law or a state law, a security is going to relatively be the same in terms of the definition. So it's easy to say, okay, I'm selling stock. Clearly, I'm working with a security, but there are some catch-all provisions in the Act, and probably the most known and widely tested catch-all is this investment contract concept. And the Act referred to an investment contract, but it didn't really go into the detail of what did that exactly mean. What is an investment contract? So the framework of applying this catch-all to everyday life didn't come about until a case called HOWEY, and what is now known as the HOWEY test. And the HOWEY test kind of said, okay, we've got this catch-all under the Securities Act. They didn't really define what it meant. What is an investment contract? Well, looking at the objective of securities law, we want to get people information, particularly when they're not, involved in the business. What should an investment contract mean? So there are, 4 elements to an investment contract. One is, someone's paying money. Someone's putting money into, a business is the easiest thing to think about. And common enterprise, that's the business, right? There's a group of people with a coordinated effort to, grow that operation. And, when you go into business, what's the expectation? We've got an expectation of profit. And what do the investors have in that expectation? They want to get some money. Otherwise, why am I giving you my money to buy this piece of paper? And the fourth element is kind of this earned solely through the efforts of others. Again, that's the real key piece when you think about the securities law objective. Is, again, we're trying to protect investors that don't have information and can't readily get the information. If you're active in the business and part of the rise and fall of your decision to put money into that business is based on your own efforts, I'm the CEO. In some instances, the Securities Act, it does care about that stuff, but not to the same degree as, Joe Schmo off the street that, just has a bunch of money that he's looking to put into work, and really has no participation at all in the business. And the HOWEY case had an interesting fact pattern where, instead of forming a corporation and selling stock, a group of people who wanted to operate this orange grove said, hey, instead of doing that, why don't we just take the position that we are selling, a shared interest in the underlying tree that is in this grove. That's not stock. They're buying essentially, an interest in this land. And, yeah, they're not going to be involved in the business, and yeah, they're going to earn a profit if we succeed in this grove, but hey, we're not issuing them a piece of paper, so this isn't a security. And the HOWEY case looked at that and said, we're going to put substance over form here, and we think this is an investment contract, notwithstanding that you're not operating as a corporation or any other business enterprise. People paid money. It was a common enterprise where, people were working together to harvest this grove. The investors had an expectation that, I'm giving you this money and I want some return on that, on those dollars that I've given you to operate this thing. And the investors weren't involved at all in the grove. There were, third parties that were running the day-to-day. So it was an investment contract, and because it was an investment contract, it was a security. And because it was a security, there were some formalities that, the Orange Grove had to comply with. And putting the catch-all in kind of today's market of when you think about the test, LLC interests or units, that's been viewed as, certainly an investment contract when you're talking about passive investors. LLCs didn't exist when the 33 Act was passed. So, there was a question long ago of, hey, what are these things? And, most typically it's easy enough to say, investment contract. If anything else, they're an investment contract. People are putting in money to a business. They're expecting a profit, and it's based on the efforts of third-party people. A recent note are these kind of initial coin offerings, which I don't pretend to know all the ins and outs about the technology involved, but people were saying, we're selling these, utility tokens that are, give people certain advantages, but they're not securities. And a lot of practitioners kind of sat back and say, well, gee, if you look at HOWEY, it certainly looks like an investment contract. And there were a lot of creative arguments that were saying, why it isn't and it shouldn't be. The SEC did ultimately issue some guidance about, hey, we're taking a hard look at these, tokens and coin offerings. And in some instances, they made decisions of, hey, we think this is a security and there's an enforcement action that's coming down your way. So, you got to be careful when as time evolves and there are these new kind of creations, you want to really think about securities law when you've got an outside person putting money into an enterprise. No matter how you style what they're getting, first thing you should always do is look at the HOWEY test and say, okay, we've got somebody putting in money, does it meet these four factors? And if it comes anywhere close to it, you've got to take a pause there and figure out, what the right approach is. Because again, there can be some serious consequences to not complying with securities law. Another interesting thing about the definition of security outside of this, investment contract catch-all is a lot of people are surprised that promissory notes can be securities, even if it's straight debt. So, a convertible note where by its terms you have the option or opportunity to convert it into equity. I think most lawyers will look at that and say, okay, that's a security. There's some option to get, stock, and I know stock is a security, so that must be within the framework of securities law. A lot of people kind of dismiss debt as, it's debt. It's kind of an ordinary transaction. People loan money all the time. If you look back at the definition of what a security is, one of the first things it says is a note. A note is a security. Now, developed under case law, that position is softened a bit in that a note is presumed to be a security, and you can rebut that presumption under what's called a family resemblance test. And this is a test that's been developed through, mainly federal law, particularly the Supreme Court case called Reeves, where, there are factors that a court will look at to say, hey, we've got a note here, was it a security? And certain things have been ruled not to be securities, even though they're notes, at least at the federal level, consumer financings, debt that is secured by a mortgage, or certain short-term notes that have some collateral that serves as a security interest. When you're dealing with a commercial bank, those types of notes are not securities for these purposes. So you're really focusing on, I've got a private person that wants to lend money to a business. Am I dealing in a security? And under the family resemblance test, you look at the motive. Why is the company looking for this money? And why is the person lending the money? Do they have an expectation of profit? Again, kind of touching on the HOWEY test. The other piece you look at under the family resemblance test is, how is the note, quote unquote, distributed? Is this note being issued, and will it be held by the person who actually lent the money to the company? If that's the case, it looks less like a security. If the note is something that is tradable, the person is just lending the money and they're planning on trying to sell the note or assigning the note for some other value, that's a plan of distribution that kind of makes it look more like a security. Another factor is the public and private aspect. How widely sold are these notes? Is this a one-off? How does the public at large, what's the perception of this financing? And the other, factor under the family resemblance test is whether or not another regulatory framework exists outside of securities law that kind of serves the same objective. It's protecting the person who's lending the money. Because if they're protected under some other regulatory framework, it's not as important that the note be held as a security for compliance purposes, because there's already other regulations that protect the people involved. So it's always, something to keep in mind that, hey, notes might be securities and you need to think that through. I think a lot of times as a practical matter, you'll find that, there's good arguments that, particularly for our clients, that a note might not be a security. And even if it is, there is usually an exemption available, which is a nice segue into the next slide of, let's say I do have a security. What do I do? Let's say I'm representing a company that wants to raise money, and the way they're raising money is selling a security. So there are three options in how your client can sell that security. One is registering the security. I mean, typical, think of an IPO where they're registering the security and the description and all of the disclosures and bells and whistles that come with that. They're making that publicly available through a filing with an agency like the SEC. Say, hey, I'm selling this thing. The other option, which is what our clients are really trying to get to, and what my practice focuses on, is it's an exempt from registration transaction. And that can either mean that it's an exempt security or it is an exempt transaction. We typically involve, our involvement is in exempt transactions. Just to give you an example of what an exempt security is certain 501c3 charitable organizations that are, selling, stock or some kind of member interest for financing purposes. Typically, those things will, yes, they're securities, but they're exempt from registration. Exempt transactions are, it's a security, There's nothing unique about the security that would make it exempt, but the transaction itself, the people that are involved, what the offer and sale looks like, you don't need to register it. And then the third option of how to sell a security is doing it illegally, which is what we're trying to avoid. So the bottom line is you either need to register the security that you're selling, or you need to find some exemption that applies to that sale of the security. And as I said, the focus of this presentation and what we focus on for our clients, it mainly falls under what's called a Rule 506, which, I'll get into more detail, but, that's kind of the bread and butter of what our clients do when they want to raise capital. And it's what other businesses do. Certainly privately held middle market businesses rely heavily on this Rule 506. So keeping that in mind, you've always got to just plan ahead before any offer or sale of security, because you don't want to fall into that third bucket of having an illegal sale. Going back to the first slide, there's a lot of risk in doing that at an agency level, private action, and future deal making. Even if you do have an exempt transaction, while some transactions are self-executing, meaning you don't really have to do much to rely on the exemption, many of them require some affirmative filing. 506, as I mentioned, that requires filings. It requires a filing at the federal level. It requires filing at the state levels in most states. So planning ahead with the client and not just taking for granted that, hey, it's probably an exempt transaction, go for it, you really need the money, no big deal. Well, that's not true. Yeah, it's exempt. Yes, you're going to avoid a lot of the burden and hurdles of, registering the security, but there is still some legal work and planning involved. And that goes beyond just notice filings with the states and the feds to say, hey, we're relying on this exemption. So, FYI, that's why we haven't registered the security or the transaction. The biggest piece to that plan ahead is, even if you are exempt, and even if you do make those notice filings, or you have a self-executing exemption where there is no notice filing, you're never outside of any fraud obligations. And this is something that David Can, certainly runs into in his franchise practice is, remember what the objective is. The objective is to protect the investor and give them adequate information so they know what it is they're investing in and can understand the risks. So, there is a lot to be said about companies that do these types of sales. They have an exemption in theory, but then they don't follow it through with adequate disclosures and giving their prospective investors adequate information. And that can jeopardize the entire exemption. I mean, it can almost completely gut it. So, you gotta plan, you've got to plan well before any offer or sale. Part of that planning is looking at the state laws as well. So you got to remember that, not only do the feds have a say in securities laws, but so do the states. So if you're selling to an investor in California, California's got something to say about that. And there are certain states that are particularly onerous in how they approach securities law. And an example is New York. And just to kind of put this into context, one of the reasons why we like to rely on Rule 506 is because it almost universally preempts any state law. So, the SEC and the feds have said, if you're doing a 506 compliant offering, the states cannot require more than what we require for compliance purposes. And usually that will mean that states can, require the notice filing. They can require a filing fee. A state needs its pound of flesh, so they want some money out of this, if you're a skeptic. And then the state can also impose its anti-fraud rules. Hey, look, you got to give people disclosures. But outside of that, if you're doing 506, that should be the end of the compliance efforts. New York, historically, it hasn't updated its regulatory framework, although as recent as a few months ago, there are some proposals on the table to bring it up to date. But New York has taken the position that, hey, even if you're doing a 506, not only do you have to give us a notice filing, but you need to give us the notice filing before you even make an offer in our state, which is inconsistent with Rule 506 generally, that says, hey, if you're doing a 506 offering, give us the notice, but you have 15 days after you sell the security to give us that notice. So New York wants advance notice. They will also usually want the offering documents and kind of, show us what investors are signing. So it really gets into the detail about the offering that you don't have to provide in, frankly, most other states and at the federal level, which is the beauty of 506, but New York is one of those oddball things. There are some alternative positions and approaches to how to comply with New York and whether you need to comply with New York at all, which is probably beyond the scope of this presentation, but there have been some practitioners that say, a state like New York has overplayed its hand and, we're not making the filing. New York obviously takes a different view on that, so there is risk to taking that approach, but, people do it. So 506 is kind of a little black dress, right, of where, hey, it's streamlined, it helps us avoid doing a 50-state survey of all these different regulations and compliance efforts. And if we can get it into 506, boy, will our client be happy, because they don't have to do, all these hoops and hurdles. And it's a very one size fits most type of transaction, so long as we make the filings and comply with any fraud obligations. And what's interesting about 506 is that there are two types. There's 506B, which has existed for quite some time now, and then of recent event is Rule 506C. And they're a lot alike, but they're different in a couple of respects. Both 506 offerings, you can raise an unlimited amount of capital. If I want to sell $1 million in securities, 506. If I want to sell $100 million in securities, I can do 506. It can be used pretty much by any business organization. There are bad actor requirements under both compliance frameworks. This goes back again to my very first slide, where if you blow securities law compliance, or if you've run afoul of certain other laws and regulations, you might be prohibited from relying on a 506 offering. And that's a problem, particularly when 506, again, it's our go-to for most of our clients. And many transactions can fall within 506 pretty easily, but you've got to do your diligence to make sure that there are no bad actors involved in these companies because you might not have an exemption anymore. The type of investors that can invest in 506 offerings. Under 506B, you can have an unlimited number of accredited investors, and I'll explain what an accredited investor is. It's usually people of high net worth, and they have kind of the financial wherewithal where the law presumes that, hey, you've got money, you know how to protect yourself, and if you don't, you can hire people that can protect you. And I'll get into some detail on the next slide about different buckets an accredited investor can fall into. 506B also allows for non-accredited investors, up to 35 non-accredited investors. And these are people that, are sophisticated either themselves or they have a representative who is sophisticated, kind of, kind of the path of what it means to invest in, a company and what the risks are, and in part with our disclosure obligations under any fraud rules, we'll tell you about the business, we'll tell you those risks, but you kind of already understand what's going on. The problem with, it sounds good in concept, right? Where, hey, I don't have to find all these high net worth individuals to invest in my company. I can also kind of, target, your blue collar guy off the street. Good in theory, not so good in practice. I mean, a lot of our clients do not conduct offerings under 506 that involve non-accredited investors. And the reason is that there are heightened anti-fraud obligations when you have a non-accredited investor involved in your offering. For accredited investors, the law doesn't mandate any disclosure at all. It's usually, just comply with anti-fraud, which is, an open-ended concept, material information an investor would use to make its investment decision. If you've got a non-accredited investor, part of that anti-fraud obligation also involves mandatory disclosures. And without getting into too much detail, it depends on the size of the offering and the nature of the offering. And, it can include audited financial statements. It can include information in this disclosure that you would almost expect from a registered security. So you're almost recreating this burden that you were trying to avoid initially by trying to find an exempt transaction or an exempt security. So a lot of times, this becomes too costly for a client where, you want to take $10,000 from somebody that doesn't qualify as an accredited investor. You're going to be spending, $40,000 to $50,000 in accounting and legal fees just trying to meet your compliance because you've now got that one non-accredited investor in your offering. So conceptually, yes, 506B has non-accredited investor participation, but in practice, usually not. 506C, on the other hand, no non-accredited investors. You can only offer to accredited investors. And in terms of, who's accredited, we've got, directors and executive officers, people involved in that business. There's a whole host of people who qualify as being accredited. You've got the high net worth individuals. Either their net worth or joint net worth with that person's spouse or spousal equivalent is in excess of $1 million. And that test excludes some assets like your primary residence. It's almost like the net worth test is almost like a liquidity test of, hey, you have investments and cash and other things that total more than $1 million. Or that person has earning power. So the third one is, income in excess of 200,000 for the most 2 recent years, or joint income in excess of 300,000. And then there's an expectation that they'll continue that same level of earning power, or something greater. You've also got, we were talking about individuals, you've also got companies and business organizations that can qualify as accredited investors. Typically the rule of thumb is they've got to have total assets in excess of $5 million, and they can't be formed for the specific purpose of investing in the offering. So take, for example, you've got 10 non-accredited people that want to invest, and in the aggregate their total investment is $10 million. So they say, oh, well, why don't we just put that money into the LLC? The LLC invests $10 million, and its assets were 10 million. Doesn't that meet the test? And the answer is no. It doesn't. You can't commingle those assets to try to create an accredited investor for the purpose of participating in an offering. Another accredited investor type is certain professionals, and this is a recent update. So if you've got forms that talk about who's accredited and who's not, as of August 26th, there has been an update, and they've expanded the list of who qualifies as an accredited investor. One of the interesting ones is this last one of people that hold professional certifications. You'll see that it's Series 7, Series 65, and Series 82 licensing. So we're talking about financial people, right? At least at the moment, those are the only certifications that if you have that certification, you're an accredited investor out of the gate. Now the SEC has reserved rights to expand that list through additional regulations, but at the moment, these are the only certifications that qualify for accredited investor status. Going back to the 506, we talked about accredited investors. Okay, so how do I tell if somebody's accredited? Well, under 506B, you just have to have a reasonable belief that they're accredited. And that can be done through self-certification, where the investor says, hey, I'm accredited, and the issuer has no reason to doubt them. So, an example is, you can't have your uncle who makes minimum wage simply sign a piece of paper that says, yeah, I'm accredited, and rely on that. You don't have a reasonable belief. But if you, are working with someone, you don't have intimate knowledge about who they are, what they do, but you've got no reason to believe that they don't have the financial wherewithal to be an accredited investor, and they so certify to that, you're usually in pretty good shape. 506C says that you basically have an affirmative obligation to investigate and make sure that the people participating in a Rule 506C offering are accredited. And you might be sitting back and wondering, well, why is there more of a burden under 506C? There's two potential burdens, right? Is one, I can't have any non-accredited people, and two, there's accredited people. I somehow have to do a diligence process and make sure that they are in fact accredited. And the reason is, under this prohibition on general solicitation or advertisement, 506B says you can't generally solicit people. 506C says you can have general solicitation. So long as everyone's accredited, so long as you've done an investigation to determine that they are so accredited, communicate it out to the world that you're raising money, and you can generally solicit under 506C. And what is general solicitation? Again, 506B says you can't do any general solicitation. 506C says you can, so long as you verify that your people are accredited investors. So how do you avoid general solicitation? Mainly, you have to have some type of pre-existing relationship with the prospective investor. And that can be either a relationship you have personally, or you can sometimes piggyback on other third-party relationships. Like if you've engaged a broker dealer to help you sell and market your securities, if they've got a book, you can, almost through, proxy say, I've got a relationship with that person because my broker knows them, and we've got some prior dealings with those people. Again, 506C doesn't put any of these burdens on. You can communicate it out broadly. The reason why a lot of people still aren't doing 506C though is because of that independent investigation they have to do to confirm everyone's accredited. You got to get people's tax returns, you got to get personal balance sheets, things like that. And a lot of people are uncomfortable doing that. They don't want to take that burden on. They don't want to take that risk of getting it wrong. So they like the self-certification aspect of 506B. And then they avoid the general solicitation prohibition. They avoid running afoul of that by simple things. You don't post things on websites. You don't broadcast it on social media. You got to be mindful about how you respond to any press inquiries after filing a notice with any state or federal agency, because those are of public record. So 506B is usually the predominant transaction exemption under Rule 506 generally. And then just to reiterate here, exempt transactions are not a free pass. You do have anti-fraud obligations. You have to give adequate disclosure to your people so they can make a fully informed, eyes wide open investment decision. And you can either do that through, a business plan and, private placement memorandum that goes through all the ins and outs about, why investing is risky, or what's risky about the company, and, whether its management is experienced or not. What's risky about the company's industry? There are unique risks when you're dealing with a company that works in the healthcare industry versus a company that operates in the food and beverage industry. So a lot of clients kind of get put off a bit because, hey, we're trying to raise money and you're saying that we have to roll out this parade of horribles about all the risks involved in investing. And my response is always, look, if you're working with accredited people, which you should be, again, because it simplifies compliance, they should not be shocked in any way, shape, or form by these disclosures. They're common practice because of these compliance efforts. And if you do have somebody that is off put by the risk disclosures, that's achieving the securities law objective. I mean, you need to make sure your people investing are comfortable because it can come back to bite you. And with that, a lot of ordinary transactions can't be overlooked. Always be mindful of the passive investor. They're putting money into a business that they're not involved in. Related to that is there is no friends and family exception. Even if your mom wants to invest in your coffee shop, you're still selling a security, and there is still securities compliance efforts that need to be addressed. Equity compensation, that's a security. There are exemptions that apply, but it's still a security, and most notably, the exemptions at the federal level do not preempt state law like a 506 offering would. So you do have to look at each individual state when you're doing equity compensation. And then intrastate offers and sales. I'm only offering in Maryland. I'm a Maryland business. Okay, maybe you're outside of the act from a federal perspective, but Maryland still has a say in what you're doing. So don't overlook the states. The states have rights, states have regulations, and it's important to comply in all jurisdictions in which you're making an offering. And with that, I've kind of given you the parade of horribles about securities law compliance. I'm open to taking any questions, and hopefully I can address any concerns that somebody might have if they've had a recent experience on a securities related issue.
Thanks so much, Ryan. That was a great overview of securities law for the general practitioner. On behalf of White for Taylor and Preston, thank you for joining us.